looking at. So, of course, we are still looking at judicial review. And from my recollection, last week we were looking at the case of Associated Provincial Picture Houses versus Waynesbury Corporation. Now, I'm not very sure if I had given you any assignment to do for us to discuss today. But if I did, of course, then it would be very good if you could guide me on that. Otherwise, we are still looking at judicial review. Nicolette, are you able to guide us on where we ended last week?
I was not in lesson last week.
You were not in attendance last week. Okay. Those of us that were in attendance last week, are you able to guide us on where we ended, members?
From my recollection, sir, we had concluded with the reliefs for judicial review. I do remember that you had given us the case of R versus Medical Appeals Tribunal to go look at and come and discuss today.
Okay, very good, very good, very good, Hazel. So I gave you the case of R versus Medical Appeals Tribunal, ex parte Gilmore, and the reason for me giving you that case was simply to show that though, as we looked at the case of Bedford Lushakangombe, where the matter had to do with the president, which president, according to the law in Zambia here, is immune from any legal proceedings, be it in a criminal or civil matter, as long as they are in office. We saw, however, the case of Bedford Kangombe, there was an application for judicial review that was made against the president. So now the question would be, but doesn't that go contrary to the principle of immunity that the president enjoys? So we know that immunity does not necessarily mean immunity in absolute terms. We know that immunity is not immunity in absolute terms. Immunity is immunity only with regard to legal proceedings or an appeal, as in the case of, in the case of Gilmore. In the case of Gilmore, if you recall, Lord Genning, in that case, Lord Genning said that there is finality. There is finality, yes, but that finality is only as far as the issue of the facts is concerned, not on the issue of law. So where there is a gap, in terms of the rule of law, there cannot be. Who can tell us something briefly in terms of the facts? Who can briefly tell us something in terms of the facts? In the case of R versus Medical Appeals Tribunal, ex parte Gilmore. Members, anyone to tell us something in brief? What are the facts in R versus Medical Appeals Tribunal, ex parte Gilmore? What were the brief facts, members? Anyone? Is anyone able to tell us something, members? What were the brief facts in the case of Gilmore? Hello, members. Anyone to quickly come in and guide us on that? That's the case we said we should basically go and read. Hazel has just reminded us that we said we go and read that case. So what were the brief facts? Very, very briefly. And what was the decision of Lord Denning on the issue of that exemption clause? You know, the clause in that piece of law that purported to exempt the decisions of a tribunal from any appeal, and an application for judicial review was brought. And the contention was that we rely on the clause which basically says the decision of a appeal tribunal are final. But Lord Denning did not agree. And he said, yes, finality as regards the facts and not finality as regards the law. What were the brief facts, members? Is anyone going to guide us, members? Could someone guide us, please, members? Who is going to guide us? Somebody should guide us. How many did not read? Maybe that should be the question. How many did not read? The case of R versus Medical Appeals Tribunal ex parte Gilmore? How many did not read the case? Those that didn't read the case, let's put our hands up, please. Nicolette did not read it because she was not in class. Okay. How many others did not read that case? Okay, so Richard, Angel, and Hazel all read the case. So any one of the three can then tell us what briefly the facts of a case were before we dwell into something else. I would like us to look at the reliefs, the specific reliefs. I'd like us to, to look at the specific reliefs in judicial review applications. So the quicker we can look at the brief facts in the case of Medical Appeals Tribunal, the better and quicker we look at. We look at the other topics that we are supposed to be looking at. Richard, would you like to come in? Come in. Come in. Morning. Morning. Richard, would you like to come in? Hazel, would you like to come in?
Okay, sir. So in this case, Mr. Robert Gilmore had applied for an order of certiorari to remove a decision of a medical appeal tribunal so that they could quash the decision. So the decision basically concerned the proper application of a statute, and the statute was the National Insurance Industrial Injuries Benefit Regulations 1948, which basically stated that an injury a person could get, if a person lost one eye, then their disability was assessed at 30%, but if they lost two eyes, if they were disabled in both eyes, then their disability benefit was assessed at 100%. So Mr. Gilmore was injured in both eyes by burns that he has sustained at his job.
Yes, carry on. Those facts are coming out very, very well, Hazel. Carry on speaking, please. Hello, Hazel.
Sorry, sir. So then Mr. Robert, once he had sustained both injuries in both of his eyes, he proceeded then to claim the disability benefit under this statute. But the first medical board basically stated, when they assessed the degree of his disability, they said that he could not be awarded the disability at 100%. And then he made an appeal to the Medical Appeal Tribunal, who then asked the specialist to examine him. And when they did examine him, they found that he was indeed disabled in both eyes, and he was entitled to the 100% disability. Yeah. I
Then
think
what happened after that? Where did the application for judicial review then come from?
sorry, where did the application for judicial review come from?
Yes.
I would assume it came from him because while he made the application to the court to issue the decision of the Medical Appeal Tribunal for error of law on the face of the record.
Yeah.
Yes.
So there was a decision of the Medical Appeals Tribunal that was not in his favor, isn't it?
Yes.
Yeah, and he sought an application for judicial review, and the contention of the counsel for the Medical Appeals Tribunal was that the decision of the Appeals Tribunal was final and could not be questioned. And that is where Lord Denning then had to deal with the issue of finality. So this, in line with the case of Kangombe, tells us that although in the Kangombe case, the president had immunity, the president did not, however, have immunity on matters pertaining to review. If he did not act in accordance with the law, yes, he was not being brought to court by way of a legal suit. He was being brought to court by way of an application. And what basically the case of Kangombe tells us and the case of Gilmore tells us is that there will be certain provisions of law, yes, that may immune you from legal suits, but will not immune you from review. So it's a distinction. We need to draw the distinction between a legal suit and an application for review. You can be immune from a legal suit, but you cannot be immune from a review. So an order of certiorari can be made to quash a decision that you have made if it is made without legal authority. An order of mandamus can be made against you if you have failed to follow procedures as are laid down in the law. And equally, both an order of mandamus and an order of prohibition together, these can be made to order you to go back to the decision-making process and be required not to act in a manner you might have acted earlier, as the case was in the case of Associated Provincial Picture Houses versus Wendbury Corporation. Had the applicant in that case succeeded, the court would have made two orders. One, an order of mandamus, and secondly, an order of prohibition to prohibit the decision maker from taking into account what they ought not to have taken into account, or to take into account what they omitted but should have in fact taken into account. Yes, Nompumelech.
So say the owner of security
Security, yeah.
is given when there is no authority establishing the decision you make.
Okay, so Nompumelelo is asking that, so the order of certiorari is made by the court when a body has made a decision without legal authority. I will not answer that question because now Nompumelelo, we are looking at the specific reliefs. We are looking at specific reliefs. Now, we said that each ground has its own specific relief. And as an advocate, as counsel, you need to know which ground or which relief accompanies this ground. As counsel, you will basically need to know which relief accompanies which ground. Because there are instances, members, when one has applied for judicial review, and what you are asking the court is to, in fact, substitute the court's decision for that made by the body, which in essence is not an application for judicial review, but a legal suit. And that is what happened in the case of Nyampala Safaris versus Zambia Wildlife Authority. The applicants there, forgetting what they had initiated was an application for judicial review. But what they wanted the court to do was to reverse the decision of ZAWA, Zambia Wildlife Authority, and for the court to replace its own decision with that of ZAWA. And the court reminded the applicants that that is not the principle of judicial review. Judicial review only looks at the procedure, the process, as opposed to the outcome, the decision of the process. So, Hazel, you are very right. It means that we have read. It means that we did read the case of R versus Medical Appeals Tribunal ex parte Gilmore. It's a very, very important case when it comes to finality clauses. Very, very, very important. You will have, especially tribunals, especially industrial relations related tribunals. We refer to these tribunals as administrative adjudicative tribunals, administrative adjudicative bodies. The tribunals are basically referred to as administrative adjudicative bodies. These are bodies that perform judicial functions administratively. They are not part of the court structure, but these are found in organizations, for example, even in companies. Companies, you will find a tribunal. For example, before somebody is dismissed from employment, whatever reason, a tribunal ought to be set up to inquire into the reason why this person is being dismissed. And only after the tribunal has established that indeed this person acted contrary to the code of conduct that the company has put up for itself, only then can this person be dismissed. So that is known as an administrative adjudicative tribunal or body. Some of them, when they are established by statute, they are actually established with express provisions saying that the decisions they make shall be final, meaning not subject to appeal. But when they make that provision, it is not to say they cannot at all be questioned. They can be questioned, only that the manner in which they would be questioned would not be by way of an appeal, but by way of a review, which is to say that they have acted contrary to the law, either in terms of the legal authority, in terms of the procedure, or in terms of what they might in fact have taken into account when they were making the decisions that they actually made. So the case of Gilmore is an important case. I remember in my first year, 2001, these are the cases that we were learning about. These are still laws today. So you can't say, no, but that's an old. There are cases like the McNaughton case, 1600. I'm sure you've learned about McNaughton in criminal law. Yes, the burden of proof in cases of insanity, the McNaughton rule. He who asserts bears the burden of proof. When you assert a defense of insanity, the burden is on you to prove that you were insane, isn't it? Yeah. Okay. So, members, let us now look at the aspect of reliefs. And I think we started. No. Okay. Now, I think the reason why I thought we started is that I asked the question.
You just told us that when we're going to look at a specific reliefs,
Yeah.
then after that we'll now move on to the next, which is judicial outcome.
Yeah, very good. So, I remember asking a question. The question was, how many remedies are there in law? How many types of remedies are there in law? I think I asked that question. I asked that question because I think we are looking at the order of mandamus. And we said that the order of mandamus falls under, in private law, it is known in a different manner, but the effect is basically the same. In private law, what did we say order of mandamus is? An order of what? Specific relief. Yes. Or specific performance, rather. An order of specific performance. That is what we said mandamus is. So now, we want to look at two different types of remedies there are. Now, remedy is a general term for a relief that you are going to receive. That there are specific reliefs. These reliefs are known as what? Generally are known as what? Remedies. Now, there are two types of remedies in law. We mentioned them, and we say that the order of specific performance falls under one of the two. Which are these? One is which one, members? We said? Sorry?
Private remedies.
That's not what we say. What are these remedies, members? We say that there are two types of remedies. What are they called? Our friends listening to us online, what are these two types of remedies we say? Yes, Hazel?
I'm just attempting, sir, but are you talking about the declarations and injunctions?
Okay, so those are specific reliefs now. So those specific reliefs fall under specific or general remedies, rather. What are these two general remedies? Tyler, what are these two general remedies under which those specific reliefs that Hazel just mentioned for? Okay, so all right. So those four. So one of them falls under the other, and the other falls under the other. So which are the general now? Yes. So those fall under different categories or types of remedies there are. So Tyler says injunctions and damages, and I said those are specific reliefs, and they fall under one. Each one of them falls under one of the two. So which are these two? No. Not exams. Not just now. We will be talking about exams when we finish, when we start revising. For now, okay.
Pertaining to reliefs and remedies, are they the same thing if they went with a slash to say or?
So the remedies is generic. Remedies is a generic term. There are two types of remedies. Then reliefs are specific. They fall under the two the different types of reliefs there are fall under the two different generic terms known as remedies. Yeah, so no, they are remedies. The general term is remedy, but under remedies are specific reliefs. Yeah. So what are the two different types of remedies there are? Yes,
So
Mr.
there is injection and damages.
Yes, they fall under different remedies.
So an injection is more like a conforming remedy.
Is more like a what?
Conforming.
No. Injunction is a preventative measure, prevents you. Whereas an order of specific. But you're asking me questions. Don't ask me questions, please. I have asked you questions. Members online. No. There are remedies. There are two different remedies. So I want us first to identify those. Yes. So what are those remedies? Our friends online. Angel, Loso, Nicolette, Hazel. I don't know where the rest of them are. Yeah, the Gamchirais, the Tambatares, and everyone else. Challenge has really stopped attending. I don't see. Okay, anyway, it's fine. They are always listening to recorded lectures. But there are two different types of remedies, known as, I mentioned them last time, known as legal remedies. And the other one is which one? So legal remedy, and the other one is which one? The other one is equitable remedy. So there are two different types, members, of remedies. So these specific reliefs that are going to be ordered by way of judicial review, they fall under one of them. They fall under one of these specific or general remedies that we have just talked about. So legal remedies and equitable remedies. Legal remedies and equitable remedies. Now, in the law of contract, they both apply. And not only in the law of contracts, in the law of torts as well, they both apply. Yes. For example, let's just say what these are. Legal remedies are remedies that you have as a matter of right. Yes. They are an entitlement. So legal remedies, members, are remedies that you have as a matter of right. They are an entitlement. You are entitled to them. Among them, and most prominent of all, is damages. Damages are a legal right. When you have suffered a damage, you have the right to be compensated, provided you can prove the damage that you suffered. However, there are equally other instances when you do not have a legal right to a claim, but the court thinks that somehow a right must be, or a compensation must be made available to you, or that a solution, a remedy must be made available to you. It is not a right, but the court thinks that it will be just unfair, hence equitable. Remember that equitable is derived from the term equity. Equity means just unfair. That which is just the right thing to do. It may not be an entitlement that you have, but it is just the right thing to do so that there is some fairness in the person aggrieved.
So can you say it is awarded due to discretion?
Yes, of course. That's the whole idea. Nomumelo is saying, so can we say that equitable remedies are awarded at the discretion of a court? And we're saying, yes, equitable remedies are not an entitlement, but the court will be guided, members, by the maxims of equity. Equitable remedies are going to be, the courts will be guided by the maxims of equity. Among the main maxims is equity is equity. Equity is fair. Equity is equity, equity is fair. So equity will call or will demand that that which is equitable, that which is fair, should basically prevail, even where one may not really have an entitlement. But if the circumstances are such that certain decisions should be made, which decisions are going to make it fair for one to be awarded some form of relief, the court is going to use its discretion to actually award that relief. So, among the equitable remedies, you have now, Kyla, an order of specific performance, which in public law we refer to as an order of mandamus or a mandatory order. Among the specific reliefs, we also have what is known as an injunction, which in public law we refer to as an order of prohibition. So you are being prohibited from continuing to do something that you ought not to be doing.
So an injunction falls under specific.
No. It falls under equitable remedies. Specific performance is an order that you act when you have failed to act. For example, in Zambia here, I always say that in Zambia here, it's only that I think us lawyers, we are so preoccupied with profits. Otherwise, there are so many things that we should be taking to court because public bodies are not acting. We go to court and we seek the indulgence of the court to make orders of mandamus. For example, a simple thing like local authorities having to provide certain functions or certain services according to the Local Government Act and the Constitution that they are supposed to provide, but they are failing to do so. We have not taken them to court by way of judicial review under the ground of or seeking rather the relief of order of mandamus, where they fail to act, where they fail to act, a failure to act by a public body would result in an order of mandamus, basically. But I understand why perhaps we don't take the matter to court, because you have to have a ground. The ground where you attract the order of mandamus is where you say that the body has failed to act in accordance with the procedures as laid down in the law. Because remember, it is an order. It is on the issue of procedural impropriety. It is on the basis of procedural impropriety that you would seek the relief of order of mandamus. So let's look at these specific reliefs, members, that are available by way of judicial review. So we say that there are three grounds on which an application for judicial review would be made in the courts of law. There are three grounds. 1, illegality. 2, procedural impropriety. 3, Wensbury unreasonableness or irrationality. 1, illegality. 2, procedural impropriety. 3, irrationality or Wensbury unreasonableness. So let us deal with the ground of illegality. The ground of illegality attracts certiorari, which is quashing. Now, we need to be very careful not to say squash. I've heard on a number of occasions, people say squashing order. Then you say, but what do you mean squashing order? No, that is the order that the court has the power to make where the ground is illegality. So no. Please don't refer to it as quashing order. It is quashing order. To quash means to invalidate, to declare null and void. It means that it is of no effect whatsoever. So when the ground, remember, when the ground is illegality, the specific relief the court will grant here is the quashing order, known as an order of certiorari. So that thing is order of certiorari. The effect of that is to invalidate, to declare to be null and void, to cease to exist a decision made by a body. Now, I always like to clarify something about this order. We say that judicial review is not about the decision made by a body. Yet we say that when the ground is illegality, the court will quash the decision made. So how is it then not about the decision? The court interests itself with, not about the decision. The decision is merely a result of a process. So if the process itself is wrong, what makes it wrong? Because you don't have the legal authority. That is why it becomes quashed. Because the process can also be wrong under procedural what? Impropriety. But within procedural impropriety, the relief cannot be a quashing order. The relief cannot be a quashing order. The relief will be a different relief altogether, which we'll be talking about. So when the ground is illegality, the relief is certiorari or quashing order. It is not that the decision then is what is being taken into consideration by the court. No. The decision is just what the body has arrived at. And they have arrived at that decision without having the legal authority to actually arrive at that decision. Therefore, the court is going to say, because you didn't have the legal authority to make a decision that you have made, the decision cannot therefore stand. We are quashing the decision. We are invalidating the decision. So that is about an order of certiorari and illegality. So you are not going to go to court, members, and make an application for judicial review on the ground of procedural impropriety. And then you ask the court, Your Lordship, I therefore pray that you may quash the decision made by this body. The court is not going to hear you on that. So the other ground is procedural impropriety. And like we said, when we are looking at these grounds individually, we say that it means that's what it says. It means that the procedure followed was not what proper. Hence procedural impropriety. Now, what is the relief? Here it is to now, in private law, it is to say you need to act as you are expected to act. You need to act as you are expected to act. So in the law of contract, you have two parties to a contract. Each party has his or her obligation to the contract. So one party performs his or her obligation, the other party reneges on the performance of his or her obligation to the contract. And because they are failing without justification to perform, in which case the party that has performed is being adversely affected, you are not going to sue for damages. No. What you'll be suing for is that the court should order this body or this party to the contract to perform his or her obligations to the contract. In private law, we refer therefore to it as an order of specific performance. In public law, we refer to that as an order of mandamus or a mandatory order. Now, when does a mandatory order arise? So the ground is procedural impropriety. The meaning is that this body has not acted in accordance with what? With procedures that are laid down in the statute that gives them power or authority to act as they will act. But in the course of acting, they are not adhering to the procedures. And they finally make a decision, and then you are aggrieved by the decision that they have made. The grievance arises from the fact that because they follow the wrong procedure, they have therefore acted at, they have arrived rather at a decision that has adversely affected you. Because they have failed members, because they have failed to follow the correct procedure, they have arrived at a decision that has adversely affected you. So you apply for judicial review on the ground of procedural impropriety. You go to court, and the court has made a finding of fact that indeed there was procedural impropriety. The order the court is going to make in that instance is an order of mandamus. The court will now order you to go back. The court will order you to simply go back to the decision-making process. The decision-making process. How you'll be required now so two things will happen, isn't it? You'll be required now to follow the procedure as is laid down where? In statute. So the courts are not going to say, we are therefore quashing the decision. No. They're not going to quash your decision because the court has no authority to substitute its decision for that of the body. That is the law. But the court does have the power to make you, to order you to go back to the decision-making process and to require you to arrive at this. If you arrive at the same decision, well and good. So you're not going to say, Your Lordship, it won't make any difference, Your Lordship. Even if we go back and follow the correct procedure as is laid down in statute, we don't see that you are going to arrive at any decision different from what you have decided. The court is going to say, no, Counselor. It is not about the decision that we're interested in. It is about curbing arbitrariness and using discretion where the law actually prescribes how you are supposed to do it, to act. So the law is clearly prescriptive. It is saying these are the procedures that you must follow, but you then omit to follow the procedures. You use your own discretion, or you arbitrarily arrive at a decision having overlooked the procedures that you are actually required to follow. So the court is going to make an order of mandamus. Now you are being mandated to go back to the decision-making process and to be around to make the decision that you should have made. It could be the same decision that you at. The court is not concerned about that. What the court is concerned with is that a precedent is being set, that you act contrary to procedure. You'll be subject of proceedings by judicial review, and the court is going to order you to go back to the drawing board. It's about the rule of law. So the ground of procedural impropriety, members, attracts the relief of order of mandamus or a mandatory order. Then we go now to the ground of irrationality or Wainsbury unreasonableness. You go to irrationality or Wainsbury unreasonableness. Yes, no problem. Oh, okay. Okay. Now, this relief or this ground rather attracts two reliefs. This ground, members, attracts two reliefs. There would be, by the way, let me not say that you cannot ask for more than one relief. There could be certain instances, depending on the facts of the matter, where more than one relief would suffice. But in particular, in the case of the ground of irrationality or Wainsbury unreasonableness, there are two reliefs available. One is an order of mandamus, and two is an order of prohibition. One is an order of mandamus. One is an order of mandamus, and the other one is here. One is an order of mandamus, and the other one is an order of prohibition. Now, remember we say that prohibition is an injunction. Yeah. So in private law, we don't refer to it as an order of prohibition. We refer to it as an injunction. Yeah. We refer to it as an injunction. How does it work? Again, we go back to the facts in Associated Provincial Picture Houses versus Wainsbury Corporation. That's a case we looked at last week when we were looking at the third ground. And we say that it is from that case that the aspect of Wainsbury is drawn from. That it is not so much that it is in fact, it's not so much that it is in fact unreasonable, but unreasonable as had been established in the case of Associated Provincial Picture Houses versus Wainsbury Corporation. We made reference, if you recall, we made reference in the law of torts. We made reference to the law of torts, and we talked about the Bolam test. I don't know if you still remember the Bolam test. Bolam test basically is about establishing negligence in certain specific fields, like medical practitioners. In the medical practitioners, it is not me, a aggrieved person, who is going to say that a doctor is negligent. For me, I'll make a claim of negligence. But for the courts now to establish that indeed a medical doctor was negligent, there would have to come in the profession, the body that regulates the profession of what? Of medicine, to say that indeed the manner this acted is contrary to established procedures in the medical profession. So when we speak about the Wainsbury unreasonableness, we are saying it is unreasonableness in the Wainsbury sense, meaning the test that had been set in the case of Associated Provincial Picture Houses versus Wainsbury Corporation, where there the court said it is not us. We are not experts to say that this body acted unreasonably. We need to invoke witnesses who are appreciative of what the respondent was doing to tell us if they could have done the same thing or not. So Wainsbury unreasonableness simply meaning unreasonableness in the Wainsbury sense, meaning unreasonableness as had been established in the case of Associated Provincial Picture Houses versus Wainsbury Corporation. So now, there, the ground is irrationality. Irrationality means the same thing as unreasonableness, but in the Wainsbury sense. So two reliefs will be availed or available in such instances. One will be for the court, where the court has established that indeed there was consideration of matters that ought not to have been considered according to law, or that there was an omission to consider matters that ought to have been considered in accordance with the law, in the decision-making process, the court then will order mandamus. Go back to the decision-making process. But this time around, ensure to follow or to take into account those factors that you omitted to take into account, or that this time ensure not to take into account those factors you ought not to have taken into account. And because you did any one of those two things, you took into account or you omitted to take into account, you arrived at a decision that is so outrageous in its defiance of logic that a reasonable person or body could not have arrived at that decision. So if you take into account those trifles as we learned about them last week, those trifles, the court is going to make an order of mandamus. Go back to the decision-making process. When you do, the court further is going to make an order of prohibition. And this time around, please, because the witnesses, the evidence that has been laid here says that a reasonable person or body would not actually have taken into account what you took into account. So we are now making an order prohibiting you from taking into account or prohibiting you from omitting to take into what? Into account the factors you ought to take into account or the factors you ought not to take into account as you make your decision. So you'll be prohibited as you are ordered to go back to the decision-making process. So first, the court orders you to go back to the decision-making process. And as you are now ordered to go back to the decision-making process, the court is making a further order prohibiting you from taking into account what you ought not to take into account, or prohibiting you from omitting to take into account what you in fact ought to take into account. So that is what the order of prohibition is. It's like an injunction. It's an injunctive relief. So order of prohibition and an order of mandamus, or an order of a mandatory order rather. So a mandatory order in English, in Latin, order of mandamus. So members, those are the specific reliefs. However, we saw also, let me read something, let me put on the screen here. Let's look at section number 31 of the Supreme Court Act of 1980, from where we draw our judicial review proceedings. Let's look at where the court allows also for injunctive relief where there is an application for judicial review. Let us look at that. Let me just find the statute quickly, members. We're looking at the Supreme Court Act of 1980. It's an English statute. So just bear with me 1 minute quickly. Okay, we are here. We are here, okay. Okay, so let's look at that. Supreme Court Act. Okay, so under the Supreme Court Act, let us look at section 30. Under the Act, let us look at section 30. Okay, so section 30 of the Supreme Court Act reads as follows. Let's just go through it together. Among the other reliefs, of course, that would be available besides the ones that we have just talked about. So first of all, judicial review is in section 31. Judicial review is in section 31. Now, section 30 talks about injunctions to restrain persons from acting in offices in which they are not entitled to act. But let's look at section 31. Yeah, let us look at section 31. So section 31 was rather paragraph C. Section 31 says an application to the High Court for one or more of the following forms of relief. So it is not saying forms of remedies, isn't it? Have you seen that? It is not saying for one of the following forms of remedies, no. Because these are specific. These are specific. Following forms of relief, namely an order of mandamus, prohibition or certiorari, a declaration or injunction under subsection 2, or C, an injunction under section 30, restraining a person not entitled to do so from acting in an office to which that section applies. So here, it is about acting. It is not about you having acted. If you have already acted, the reliefs that are there are mandamus, certiorari, or prohibition. However, when you are acting in an office that you are not supposed to act in, there the remedy or the specific relief that availed to you is what? An injunction. You go to court and you ask the court, because you can't ask the court to make an order of prohibition. Prohibition is where you are actually entitled to act, but you have now acted in a manner that you are failing to take into account, or you are taking into account what you ought not to. However, when you are acting in an office you are not supposed to act in, and you want this person to be stopped, be prevented from acting in that office, you go to court and ask for an injunction. Now, an injunction is available both in public law and in what? In private law. In private law, you ask the court to prevent someone from continuing to do an act which is causing you damage or injury. For example, as you learned about in the law of torts, you learned that there is defamation in the law of torts. You learned that there is defamation. And you learned that defamation can be actionable per se. I hope you do remember what it means. Meaning actionable without proof of what? Damage. Meaning you don't need to wait until you have suffered damage to bring an action. So the action instead you can bring before you suffer damage is an injunction. You prevent somebody. Once you become aware that somebody is about to publish a defamatory statement about you, you rush to court before the damage is actually occasioned. You ask the court to stop this person from proceeding with that publication. That's an injunction. So members, these are the specific reliefs available to you. These are the specific reliefs available to you, depending on the ground. So depending on the ground on which this application for judicial review is based. So we need to know, because these are matters that you'll be going with to court. As long as it is an application for judicial review, be rest assured that it will be on one of the grounds. Be rest assured that you'll be seeking one of the reliefs that we have just spoken about. Okay. We end here on this topic. We introduce another topic. But questions, of course. Our friends online, do we have any questions at all? Our friends physically here, do we have any questions at all? No question from Mpumelelo. Kyla, question? No question from Kyla. Okay. Richard, Hazel, Angel, Nicolette. Do we have any questions at all? Okay, no question from Hazel. Richard, Nicolette, Angel, do we have any questions? No question from Nicolette. All right. Okay, we safely assume then that there's no question at all from anyone. All right. If there are no questions, members, let us introduce our next topic. You see, next topic is very interesting. I don't know if you are able to see why I say the next topic is very interesting. But the next question, members, the next topic, members, is very interesting because it is actually speaking about what is currently happening in Zambia here. About 3 weeks ago, if I'm not mistaken, the Republican president suspended 3 judges arising from the recommendation of a Judicial Complaints Commission. The 3 judges went to court and sought judicial review against the decision of the president. The former president, also went to court seeking the recusal of the 3 remaining judges. That is not so much what we are interested in. What we are interested in is about the code of conduct, which was the basis of the 3 judges that were suspended. Now, it's very interesting how, unfortunately, sometimes politics creeps into the judicial system. It's very interesting how politics is allowed to creep into the judicial system and to dent, if I may use the term, to dent how the justice system is supposed to operate. Politics, yeah. What are we talking about? We're talking about the Judicial Code of Conduct. The question is this, members: when judges are judging you, who is judging the judges? That's the question. When judges are judging others, who is judging the judges? And through which criteria are the judges actually being judged? It's interesting. When you look at the law, very, very interesting. When you think about these things, you say, okay, what could exactly be happening? What exactly be going on? It's interesting, and not only is it interesting, but it also becomes perplexing at the same time. It is interesting and it perplexes. Why am I saying it is interesting and it is perplexing sometimes? I say this because the former president sought the indulgence of a constitutional court to have the 3 judges recuse themselves. That is Judge Shirimi rather, Judge Mapani, and Judge Munalula. That application by the former president was based on the provisions of the Judicial Code of Conduct Act, which act we shall be interrogating here thoroughly. I want us to thoroughly investigate this act to see whether indeed the judges can refused to recuse when an application that they should recuse themselves has actually been made. That is what the Judicial Code of Conduct Act is basically about. But I was reading, I don't know if it is just social media or it is a fact. I was reading on Phoenix News that the 3 judges of the Constitutional Court have refused to recuse themselves, and in 10 have slapped a 1 million kwacha fee on the former president as costs for having brought that application for the 3 judges to recuse themselves. Now, you see, that's why sometimes being a lawyer can be very, I don't know what word I can use, can be frustrating. Because you expect the law, you read the law in this manner, and you expect a certain outcome. But when politics creep in, the outcome you expect may not necessarily be the outcome that you would see. And sometimes it is when the law could even be straightforward. But that's because there is the politics involved. So I want us to interrogate the provisions, members, of the law that we'll be dealing with here as we look at the issue of Judicial Code of Conduct. So the question is, when judges are judging us, when judges are judging others, us, who is judging the judges? Judges are not angels. They are not infallible. They are fallible. They are prone to mistake as well as a judge. Now, when they are prone to mistake, how do we nip their mistakes in the bud so that they don't actually occur? And that is why the Judicial Code of Conduct Act is there. And that is why also the Constitution is there. Now, members, as we look at Judicial Code of Conduct Act, we're mainly looking at 2 things. As we look at Judicial Code of Conduct Act, members, we are mainly looking at 2 things. First thing is nemo judex in causa sua. First is nemo judex in causa sua, which is the rule against bias. Nemo judex in causa sua, the rule against bias. Nemo, Nemo, N-E-M-O, Nemo or Nemo, judex as G-J-U-D-E-X. Nemo judex, it's not judex, it's judex, it's Latin. Nemo judex in causa, I-N-C-A-U-S-A, in causa sua, S-U-A. Nemo judex in causa, I-N-C-A-U-S-A, then sua, S-U-A. Nemo judex in causa sua. That simply means the rule against bias. Now, how does this rule apply, members? This rule does not apply only to me as a judge. It simply means that a person cannot be a judge in his own cause or matter. But it is not only about me. When we look at the Judicial Code of Conduct Act, which we are going to be looking at now, it is on this basis that the former president sought the recusal of the 3 judges. It is on the basis of nemo judex in causa sua. but this time around, not basing it on the three judges themselves being parties to a matter that they may be adjudicating on. It is about, as we shall see in the Judicial Code of Conduct Act, it is about judges having a close proximity to one of the parties in the matter. And you don't need to prove so much at all. So the balance of probabilities, you don't actually need to prove that the likelihood of bias is very high. Just that there is a possibility that there will be what? Bias. That is what the courts have actually said. So it's interesting. That's why I'm saying it's interesting. Here is a former president, members. Here is a former president who says, I want the three judges to recuse themselves from sitting in this court because one of the judges is a close relation of a president who is one of the parties to that case of eligibility. And I want the other judge also to recuse himself or herself because, again, of close proximity to one of the parties, because he has been company secretary to, before he was appointed judge, he's been company secretary to the company or the group of companies that the president, who is also party to the eligibility case. And therefore, chances of biasness are very high. And then you'll say of the other that if the three judges have been suspended based on the fact that the decision they made was not right, and if this judge was not right because they looked against one of the parties to this matter now, is again appeal. How is it then that the other judge was part of that panel of judges that sat? But because they did not make the decision against one of the parties, which is now the president, this judge is being allowed to remain in the bench. Mostly. Politics, huh? So now, members, Judicial Code of Conduct. When judges are judging others, who is judging the judges? The law is judging the judges. Which law? The Constitution, the Judicial Code of Conduct Act. So we have just said that the Judicial Code of Conduct Act is premised on 2 points. One, it is to say, are you an interested party, you as a judge in this matter? Are you interested in the outcome? Or you as a judge, are you in any close proximity to one of the parties in this matter? Isn't that straightforward? You as a judge, are you in any close proximity to one of the parties to this matter? If so, the Judicial Code of Conduct has prescribed what must happen. So let us look at, there are 2 pieces, like I've said. First, the Constitution. Let us go to the Constitution, members. Let us go to the Constitution, and then from the Constitution, we shall look at the Judicial Code of Conduct Act, which is provided for. Both, in fact, pieces of law are provided for in administrative law and process, cases and commentaries. But now, let us look at the Constitution. For now, let us look at the Constitution of the Republic of Zambia. So we are going to look at Article 43 and 44. We look at Article 43 and 44. Sorry, not 43, 143 and 144 of the Constitution. We look at Articles 143 and 144 of the Constitution. (143) and 144 of the Constitution. Okay. So 143. Clause 1. A judge shall be removed from office on the following grounds. Let's see if our friends are online are seeing what we are seeing. Okay, they are. A judge shall be removed from office on the following grounds. A mental or physical disability that makes the judge incapable of performing judicial function. B, incompetence. 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 Now, members, you see, law is very good, but only if the people that are supposed to adjudicate over this law have the freedom, like we do have as people in the profession of academia. We have what is known as academic privilege. As people in academia members, we have what is known as academic privilege. We are supposed to be free to speak about matters in order to disseminate the information and knowledge into our subjects, which is our students. If judges had that leeway, in other countries they do have that leeway, but in other countries they fear because of politics. The suspension of the 3 judges is based on incompetence. But you can't hold a judge incompetent based on a decision they have made. You appeal the decision they have made. You don't hold a judge accountable by dismissal based on the decision they have made, and you say they are incompetent. You remove a judge from the bench based on, if it is incompetence, based on what the definition of incompetence is for purposes of removing a judge, not arising from a decision that they have made. Because when it comes to decisions that they have made, you have an avenue. You appeal. You appeal the decision they have made. You appeal the decision that they have made. Okay, let's look at this. Incompetence. C, gross misconduct. D, bankruptcy. Bankruptcy. Yes.
Why?
They're not dismissed, they are allowed, they are relieved of their duty. That's a very good question. Nompumelelo is asking, why should a judge who becomes bankrupt be dismissed? Is anyone able to give an answer to that question, members? Should a judge who becomes bankrupt be dismissed? Your finances are your finances. But Nombumelelo and other members, if you are financially stressed, you become prone to corruption. Remember that you are going to be agitating in matters where someone wants to win their case at all costs, which cost includes bribing you. A lot of bribes are there, even with judges who have enough money already. But what about a bankrupt judge? Do you know what bankruptcy is, by the way? Do you know what bankruptcy is? Members, has anyone any idea what bankruptcy is? When it is said that you are bankrupt, what does it mean? Anyone to guide us, members? Yes, Nompumelelo. When it is said that you are bankrupt, what does it mean?
Your expenses or your liabilities are so much.
Yes.
More than your assets.
Yes. What do it mean? So you have borrowed so much, yet what you have borrowed cannot be offset by the assets that you have. You have assets worth 5 million. You have debts worth 10 million. Even if you were to sell all your assets, you won't be able to pay to liquidate your liability. You are a danger to the legal, to the judiciary. You know, you are a danger because you are prone to manipulation. Yeah, probably they'll just say, okay, so this judge is bankrupt. He has this much debt. Just tell him, we shall pay this debt for you. Do you know what it means to have someone paying your debt for you? It means a lot. It means that you are going to be free of debt. And the only thing is that this person is asking you to look at their case favorably as a judge. That's all. You shall pay off. It's a case of 100 million kwacha that is appearing before you, and you have a debt of 5 million. They'll tell you, it's a 100 million kwacha case, and they want you to find for them. It's a big company like Trade Kings. It's a big company like the Mines, and it is involving 100 million kwacha, and you have a debt of 5 million, and you tell them, your lordship, that's 100 million. You know, a 5 million, we shall donate it towards the payment of your debt. Of course, you know, I will find for you.
You can't ask for more.
You see, that is why you shouldn't be a judge, because you even be asking for more. So anyway, our interest here is C, gross misconduct, because it is this that the judicial code of conduct, that's why it's called misconduct. Code of what? Conduct. So gross misconduct, judicial code of conduct. So this misconduct is to be determined by what is contained in the judicial code of what? Conduct. So A, B, C, or rather A, B, and D, they are very simple and straightforward. But incompetence also comes in. What is the definition? How have the courts defined incompetence? You know, how have the courts defined incompetence? So you can't just remove a judge from the bench based on incompetence. You will need to look at what is incompetence in accordance with precedent. If there is no precedent, you can't therefore, well, a novel case, yes, but then you are going to use the aids of interpretation, the dictionary, the most reliable dictionaries. And also, you shall rely on the interpretation section in the Constitution. Now, when you look at Article 265, when you look at Article 265, you will see that there is no, let's look at it. Let's look at Article 265. It is the article that basically talks about, it is the article that talks about interpretation of terms in the Constitution. So let us look at that. The article that is talking about interpretation of terms. Let's look at that. Just bear with me 1 minute, members. Let's get to where we want to be. Let's look at okay, so let us look at Article 265 of the Constitution. Interpretation of terms, Article 265. Okay, 266, definition of terms. Article 266, members, definition of terms. In here, all the main terms that are in the Constitution are defined here. Incompetence equally ought to be defined here, but let's see if we can find it. Incompetence. Let's see if we can find incompetence. H is here, High Court. I is here, individual. So there is no incompetence. Now, isn't that an anomaly? An anomaly. Isn't that a miss? Isn't that a mistake to have incompetence as one of the grounds and yet not to define it in the definition of terms, parts of the Constitution? Yes, isn't it a mistake? Because if it's a term, that shall determine removal of a judge from the bench. Shouldn't it be very clearly stipulated here so that you know how not to be incompetent? Or we say, perhaps it is not an anomaly, perhaps it is left out on purpose so that there is a wider and a broader consideration of what incompetence is, rather than restricting it to that which may be provided for in the Constitution. In which case, then it is left to the judges. Now, judges, it means we use the aids of interpretation, like dictionaries and all those things, to determine incompetence or otherwise. Anyway, let us look at misconduct, gross misconduct. So gross misconduct is here. But gross misconduct is being provided for. Why then is incompetence not provided for? What about bankruptcy? Let's see. Is bankruptcy one of those provided for? Bill. So bankruptcy is not. Okay. But bankruptcy is a non-term, isn't it? That need to be provided for. But incompetence, because you are looking at removal of a judge. You're talking about removal of a judge being based on incompetence. It is the required thing, therefore, that incompetence must be defined. So that even as a judge is being removed, reference is being made to the Constitution, which defines what incompetence basically is. Let us go back to Article 143. Let's go back to Article 143. So Article 143 is telling us about the grounds on which a judge can be removed. And we said our interest here for purposes of the lecture, which is based on judicial code of conduct, it is misconduct. So we are mainly interested in misconduct. Now the question is, what is misconduct? There are two ways to determine misconduct. One is that which is defined in Article 266, and the other one is that which is contrary to what is contained in the Judicial Code of Conduct Act. Among them is misconduct, pursuant to the provisions of the Judicial Code of Conduct Act, is misconduct. When the parties bring it to your attention that they have reservations, that you may not act without bias, yet you choose not to recuse yourself. Because, as you shall see, the Judicial Code of Conduct Act does not say a judge shall assess whether he is actually is able to be whether he can be swayed into being biased or not. It is a provision that a judge must simply do what? Recuse himself. Could also be misconduct. Let's look at this. So C, gross misconduct. Now we say that gross misconduct arises in two ways. The rule against biasness. One, nemo judex in causa suo. A man shall not be judged in his own cause. So if you are a judge and a matter is brought before you, and there is a high likelihood, of course, not even high likelihood, the likelihood is there that if I am a judge and a matter is before me and it involves me, the likelihood is that I am not going to find against myself. And therefore, in such instances, it is required that I declare what? Interest. I recuse myself. The other instances where I am so closely related. Now, when I say close related, I'm not saying that it's a relative of mine. Close related, as we shall see here, with one of the parties to a matter. And one of the parties to the matter who I'm not closely related with there raises an issue and asks me to recuse myself. I must recuse myself. If I don't recuse myself, again, it is going contrary to the rules against what? Bias. So, when you look at the Judicial Code of Conduct Act, members, we are mainly interested in paragraph C. We are mainly interested in paragraph C, gross misconduct. Let us go back again and just see, what it means. Let's go to Article 266. Let's go to Article 266 and just see what gross misconduct. So this is what gross misconduct means, members. Gross misconduct means a behavior which brings, this is now according to the Constitution. This is according to the definition. This is general, not specific to the judges, but also applicable to the judges. This is to anyone who is in public office. Gross misconduct means a behavior which brings a public office into disrepute, ridicule, or contempt. B, behavior that is prejudicial or inimical to the economy or the security of a state. C, an act of corruption. Or D, using or lending the prestige of an office to advance the private interests of that person, members of that person's family, or another what? Person. That is what? Misconduct as well. It is said here. So, having looked at that, now let us look at the judicial code of conduct. So, in our case, we can point out that can apply to judges, isn't it? A judge's conduct may bring the office of a judge into disrepute, into ridicule, or into what? Contempt. Perhaps not so much prejudicial to the economy or the security of a state, but also perhaps the security of a state. Corruption, of course. Then D, lending the prestige of an office to advance the private interests of that person. As a judge, you are now completely swayed by the principles of justice, that you start looking at your own personal agenda as a judge, private interests of that person, members of that person's family, or another person. So, means that D and A, yes, Kyla. About D. We shall look at this when we actually start looking at the Judicial Code of Conduct Act, because it has given these examples. Yeah. D has given these examples, and there is case law to this effect that we shall look at. Yeah, there is case law to that effect that we shall basically look at. Yeah. So, gross misconduct for purposes of our discussion is A and D mainly. A and D mainly. So, let us look at the Judicial Code of Conduct Act. Let's look at the Judicial Code of Conduct Act. Let's bring it up on the screen. We shall have to end at exactly 12, huh? Yeah, we shall have to end at exactly 12. We shall proceed on, we shall carry on next week. Yeah, let's look at judicial, the Judicial Code of Conduct Act. JCOCA, 1999. Let's look at that act. So when judges are judging others, judges are being judged pursuant to the provisions of the Judicial Code of Conduct Act and the provisions of the Constitution. When judges are judging others, judges are being judged by the public. When judges are judging others. Okay, just a minute, members. So when judges are judging others, judges are being judged by the public. But how does the public judge you, Tyler, as a judge? The public is judging you as a judge using the law. So the public is looking at what does the law provide? And are you as a judge acting in accordance with that, what the law provides? So this law is twofold, the Constitution and this law that we are looking at right now. So let us look at the preamble to this law. That's the preamble. That's the preamble. An act to provide for the code of conduct for officers of the judicature pursuant to Article 91. Now, 91 is of the old Constitution, which is now replaced by Article 143 and 144. 141, or rather 191 of the 1996 Constitution is where provisions for removal of judges was contained. Pursuant to Article 91 of the Constitution and for matters connected with or incidental to the foregoing. Enacted by Parliament. Now, what does this act say about some of the things contained in terms of definition in the Constitution? So this does not have gross misconduct, meaning gross misconduct therefore is to be defined as is defined where? In Article 266. It doesn't have gross misconduct. It does not have gross misconduct. Neither does it have incompetence. Nor does it have bankruptcy. Meaning, therefore, that you are having to read the JCOCA together with the Constitution. You can't therefore read the Judicial Code of Conduct Act in isolation. So, gross misconduct then, in the case of our discussion, shall be as we had seen in paragraph A and D. Paragraph A and D. Let's read further. Adjudicative responsibilities. Now, members, this is what judges ought to be. This is what judges ought to be. Section 3. A judicial officer shall uphold the integrity, members, the integrity, independence, and what? Impartiality of a judicature in accordance with the what? With the Constitution. This act or any other law. So, things come up. First, we're talking about integrity, isn't it? So, judges ought to be of high integrity. Secondly, there has to be what? Judicial independence. Now, when you talk about third, there has to be what? Impartiality. These members are the hallmarks of a judiciary. When judges are judging others, judges are being judged on that. Now, when you talk about independence, there are two types of independence. You're talking about institutional independence, which is the institution of a judiciary. But then you are also talking about individual independence. A judge ought to be independent from any persuasions. The judge ought not to be influenced by any other factors, but that which is in the what? In the matter. Members, judges are umpires of justice. It is to the judges that you run. And the credibility of a judiciary shall very much be determined by these factors: integrity, independence, impartiality. Otherwise, the citizenry takes matter or will take matters in their what? In their own hands. And when the citizenry take matters in their own hands, that is the beginning of a collapse of society. That is why judges ought not to be any politically inclined at all. Because when judges are politically inclined and they are adjudicating in political matters, the other parties cannot have confidence in the judiciary. And if they can't have confidence in the judiciary, anarchy reigns, because then they take matters in their own hands. Society is destroyed. The judiciary must not just be independent, but must in fact be seen to be what? Independent. What are we saying? What we are saying is that when there is any sign that the independence of a judiciary is being somehow compromised, the judiciary should stand up through the head of a judiciary, which is the Chief Justice, and voice out their concerns. Remember that these three are co-equal organs: the legislature, the judiciary, and the executive. They have co-equal power. That is what we learned about when we were talking about the doctrine of separation of powers in the first semester. They have co-equal power. So one of them cannot act above the other organ of government. If they do so, and that somehow signifies compromise of judicial independence, the judiciary should rise up and issue their position on that. So independence of the judiciary comes in two ways: one, institutional independence, and the other, individual independence. So institutional independence is provided for in the Constitution. When you look at article number 118 to 120, it has made provisions there for the institutional independence of a judiciary. Provisions are made there for the institutional independence of a judiciary. You cannot afford to have a judiciary that is not independent. So we say that there has to be institutional independence, and we say that the judiciary should not only independent, but must in fact be seen to be independent. How shall it be seen to be independent? By how now the judges themselves conduct. It is how the judges shall conduct themselves that the institution's independence shall be determined. Besides the executive and the legislature perhaps having to interfere, but how the judges themselves equally conduct shall determine so much the independence of a judiciary. So, if a judge can't uphold the principles of judicial independence, that shall amount to what? Gross misconduct. If a judge cannot uphold the principles of integrity, that amounts to gross misconduct. If a judge cannot uphold the principles of impartiality as they adjudicate, that amounts to gross misconduct. That, members, is the basis for the removal of a judge from the bench. That, members, is the basis to seek the recusal of that judge to hear a matter if their independence is compromised, if their impartiality is compromised. We shall continue on this next week. So we are looking at, let's remember where we are looking at. It is section 3, adjudicative responsibilities. We're looking at section 3, members, of the Judicial Code of Conduct Act. Everything, by the way, everything that we are discussing here is contained in administrative law and process. Get your hands on that book, and you will learn so much of what we are looking at right now. Get your hands on that book, and you shall learn more of what we are looking at right now. So we end here. Next week, Monday, we shall carry on and finish administrative law and process. That's the book that Mr. Wesa wrote, and you can see him if you want to have a copy of that same book. Yeah. So, members, we end here for now. We shall pick it up from here next week at the same time. For now, do have a lovely day and week, and we pray for the rains to come as quickly as possible. Okay, we shall see you next week again.
Thank you.
Thank you.